we couldn't get it at the price we told you. We can only now get it at this price, and it was about $50 more. And he said, forget it, give me my $1,500 back. He was damaged at that point, and he sued because the car dealer would not give him back the $1,500.
So his damages were $50?
So it was the $1,500 times 3. But the interesting thing in this case is by the time they accumulated, by the time they took into account all the other, what we're defined as unfair, deceptive acts and practices, which each have a $200 statutory charge that can be assessed against the offender. Then they also factored in attorney's fees. There was an award to this plaintiff of over $100,000.
Oh my gosh.
So
the award was $100,000, and I'm a little confused on the $1,500.
That would be his damage. That was the amount he was out.
But how did we come to the $1,500?
That was his down payment amount that they refused to give back to him when he requested it.
I see, but the $50 was, they wanted another $50 on the deal to make it go through. So it was over $50.
It wasn't what they represented to him at the time he signed.
So in the end, this dealership, via its agents, for $50 managed to wind up, them or their insurance company, with a $100,000 award. The treble, Maryann, so that means 3 times.
Times 3.
15, 15, and 15. But our plaintiff could take that, but normally when somebody comes into our offices, they give us a retainer, they hire us.
Right.
But you're saying that in a case like this, the
plaintiff's attorney is entitled to attorney's fees if the court finds there were any unfair, deceptive acts or practices. The court may award attorney's fees. And
sort of separate from the plaintiff? I mean, the plaintiff got his $4,500.
Well, right, because here's the point of the attorney fee award. This is, again, it's a Consumer Protection Act.
Yeah.
So although generally in Ohio, each person, we follow the American rule of attorney's fees.
We hire our own lawyer.
Everyone pays for their own attorney, absent a statute or some other contract term that allows the exchange of attorney's fees. They allow for attorney's fees because they don't want a bad act to go unpunished, if you will.
Well, yeah.
Because someone can't afford their attorney. So
for the benefit of our viewers out there, and I guess we hope these things don't happen too often in our county or any county, but I guess they do. Somebody finds themselves in a position like this and said, geez, you know, $1,500, but if I do it under the local attorney, he's probably going to charge me $1,500 at a couple $100 an hour, so maybe I should just forget about this. But in this type of a case, would you as an attorney take a retainer, or would you just take the case on if you were to win, you would get your attorney fees?
Depends on the circumstances of the case, and I think each attorney would handle it differently.
Different way.
There are firms that specialize and do only consumer cases that arise out of the Consumer Sales Practices Act because they're probably set up in a way that allow them to do it on a what would almost be a contingent basis. If there's a recovery, they get their fees.
So basically, for the viewer out there who might be very upset about what happened, it doesn't necessarily mean they've got a slam dunk winner on this, but sitting down with an attorney and talking about it and evaluate it, that's how you would come to that conclusion?
Right. You should, like I tell anyone who is owed money or is suing someone for money, you always have to remember all you get at the end of the day is a piece of paper that says judgment. You're entitled to collect this amount of money. Actually getting that money is a whole different process.
We've been down that road before.
Exactly, and it's a whole different analysis.
You won.
that you would have
go
to
collect.
Right. So each case is unique, and I think what should be known by your viewers is that the Consumer Sales Practices Act does give you the right to collect attorney fees if you're successful.
I see.
And it's so that the little consumer,
Yeah.
if they have to take on a large corporation,
Absolutely.
it can actually
Levels the
bring
playing
their
field.
case
Yeah.
and levels the playing field.
No, when you think about it that
Exactly,
way, I
John.
mean, it's certainly fair. I honestly, even as a lawyer myself, read what you wrote there. You know, when the word treble came across, I mean, I never was much of a music student, but that was crossed my mind, something
It's-
about a treble. But I mean, it means triple.
When attorney, it's triple, exactly. I believe it's from Latin,
Oh,
from the
okay.
Latin.
Right, well,
when attorneys read the Consumer Sales Practices Act and the Home Solicitation Sales Act and all the remedies, not to mention all of the separate provisions that are set forth in the Ohio Administrative Code that deal with auto mechanics and car dealerships, and
they get quite specific
advertisements
I
have
see.
if a local store is advertising incorrectly and misusing
Oh,
the
never thought
word
about that.
free, that's all covered in there.
I see.
And
Pretty good sized body of law here.
it's almost shocking when you realize the remedies that are available to consumers.
Well, when you talk about, Maryann, we talk about what types of actions have been held to be unfair and deceptive acts or practices. I mean, I guess that was a pretty good example that, frankly, I don't know if I would have thought of that, advertising, but what are some other ones?
Well, sometimes the real obvious ones are any kind of untruthful statement to a consumer, anything that is misrepresenting the product in order to get somebody to sign on the dotted line.
I see. It's sort of a fraudulent
Right.
type.
Those are really obvious.
Yeah.
Some not so obvious ones are, for instance, failing to inform your client of that 3-day
3-day
right to
window. You're
cancel.
right.
That is automatically an unfair, deceptive act or practice, and you've just violated the Consumer Sales Practices Act.
You got your case there.
Done. So,
Well, to
I mean,
a trained attorney, and obviously that had to be tested in the court, so it must be good law now.
But that's the frustrating thing about this law when you represent a small business or someone who would be defined as a supplier. It's hard to explain to them because it almost defies
Sure.
common
sure.
sense when you say, well, it was a mistake, it was an honest
Yeah,
mistake. And
But the intent of the law, if you're
Right.
if you're going to hold yourself out to be in business, you need to understand that that's the rules of the game.
it's
and,
important to spend the hour or two now with an
Absolutely.
attorney.
Sure.
Make sure you're doing everything right before you venture out there, because it could save you a lot in the
This is
long
interesting
run.
stuff, Maryann. You know, do you see quite a few clients come through your door with this sort of thing?
We do. Typically, though, our firm represents a lot of small businesses. We're generally on the defense side.
Well, yeah, of course.
But,
those same clients, you could always give them good advice.
And that's what we strive to do, is talk to them before they get into
Before it
this
happens,
kind of problem.
Ounce of prevention. Well, Maryann, our time has run out. I'd like to thank you for being our guest on Law Talk today. To view this episode and others, go to www.czclip.org. I am John Celebrezze, and I thank you for tuning in to Law Talk.
To keep up on Medina County and other legal issues, go to www.czcourtreporter.com, a function of the Celebrezze-Zangi Community Legal Education Project. At CZ Clip, we're devoted to the education of today's legal issues. Fueled by the public's keen interest in our legal system and current events, CZ Clip is dedicated to the educational venues aimed at enhancing the understanding by all citizens. For a complete listing of dates and times for this telecast, tune in to WCTV Channel 15 or log on to wadsworthcity.com and follow the links to WCTV.
I'm John Celebrezze. Please join me in getting a better understanding of the law.